Now I am going to dictate a legal passage at the rate of 100 words per minute on latest Supreme Court judgment. 5, 4, 3, 2, 1, start. Let's start. This Constitution bench has been constituted to consider whether the declaration made by a Constitution bench of this court in the case of Subramanian Swamy versus Director Central Bureau of Investigation, and another one that Section 6A of the Delhi Special Police Establishment Act 1942 being unconstitutional can be applied retrospectively in context with Article 20 of the Constitution. Necessary facts relevant for the purpose of this case are stated here under. Stop here. The appellant Central Bureau of Investigation, after registering the first information report at 2 p.m. on 16/12/2004 for offences under the Prevention of Corruption Act 1984, laid a trap in the evening on the same day wherein the respondent is said to have accepted bribe to set the things right for the radiologist conducting prenatal test to determine the sex of the fetus in contravention of the prenatal diagnostic techniques within bracket Regulation and Prevention of Misuse Act 1994. The respondent applied for discharge inter alia amongst other on the ground that the trap, which was a part of the investigation, had been laid without the previous approval of the central government, as provided under Section 6A of the DSPE Act. The special judge CBI rejected the application for discharge by the order dated 30/04/2006, which was carried in revision before the High Court and was registered as a criminal revision petition number 366 of 2006. Learned single judge of the High Court by the judgment dated 05/10/2006 framed 3 questions for consideration. Stop para. If yes, does it mean that the entire trial consequent upon an illegal investigation is vitiated? It answered question number 2 in favor of the respondent, and further, with respect to question number 3, left it open for the competent authority to take the decision and further proceed with re-investigation, and in case sanction is not granted, to notify the special judge CBI to close the case. The operative part of the order is in paragraph 29 of the judgment, which is reproduced here under CRL. In the above backdrop, the matter has been placed before this bench and has been heard at length on the question referred SLP within bracket CRL number 4364 of 2011. This appeal has been filed by the appellant assailing the correctness of the judgment and order of the Bombay High Court passed in criminal application number 1913 of 2010 titled Manjit Singh Bali versus Central Bureau of Investigation dated 29/11/2010. By the above order, the Bombay High Court dismissed the petition praying for washing of the FIR registered by CBI against the petitioner therein under Section 7 and 8 of the PC Act 1988. In this case, an FIR was registered on 18/02/2010 based on a complaint dated 16/02/2010. A raid was constructed on cash was recovered from his car. In this case also, the issue is as to whether in the facts of the said case, Section 6A within bracket 1 of the SPE Act would be applicable or section 6A within bracket 2 thereof would be applicable. Stop para. Sri Tushar Mehta, Lieutenant Solicitor General, appearing for the appellant CBI in criminal appeal number 377 of 2007, made detailed submissions which are briefly summarized here under section 6A of the TSPE Act is a mere procedural provision and not a penal provision, as such would not attract Article 20 within bracket 1 of the Constitution. Article 20 of the Constitution applies only to those provisions of law in force, violation of which results in conviction and resultantly avoiding sentence. Procedural issues like statutory protection during trial, a provision providing for a particular court to try the offence would not have any bearing while invoking Article 20 of the Constitution. Para. Article 20 of the Constitution would have no applicability in determining whether. Stop.